The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your podcast on the federal courts of appeal. I'm your host, John Ross, from the Institute for Justice's Center for Judicial Engagement. And I'm joined today by IJ Senior Attorney Paul Sherman and IJ's current Galloon Fellow in Liberty and the Constitution, Anya Bidwell. We'll start things off in the Seventh Circuit in Rockford, Illinois, where in 2015, a citizen journalist took some photos of police activity on a public street. And then soon after, he's arrested. Anya, tell us about the case.
Sure, John. So this is a pretty fascinating case, though it simply applies the very recent ruling in Nevis versus Bartlett from the U.S. Supreme Court. So this is a Seventh Circuit case, and it's all about what do you have to show to establish a claim of retaliatory arrest when you sue an officer for what you think was basically his way to retaliate against you for you exercising your First Amendment rights. So really briefly, this guy, William Lund, he's a reporter. He is known to Rockford, Illinois police officers as a troublemaker. He has published negative articles about these police officers before, and they don't like him. So one day, Lund discovers in real time that the officers are running a prostitution sting operation. He rushes to the scene in his motorized bicycle and starts taking a ton of pictures. The officers notice him and they are worried that he's going to post the pictures on his newspaper's website and disrupt the whole endeavor. So they stop him and tell him to leave the scene or they would arrest him. So when he leaves, they basically think, you know what, we actually should arrest him. So they follow him for a couple of blocks and they notice that he is driving his motorized bicycle as if it were actually a motorized vehicle, like a motorcycle, over 20 miles an hour. And he's actually going the wrong way on a one-way street. So they arrest him for exactly that, right? It has nothing to do with arresting him for disrupting the prostitution sting operation. It's all about you are arrested because you used motorized vehicle, you went the wrong way on a one-way street. And also these officers publish his name and his photograph in a press release, and that press release goes in a newspaper, and essentially it's implied that he was one of the people who was soliciting prostitution services, and that has nothing to do with anything.
So to be clear, and this is something that a lot of local police departments do, when they arrest people in these prostitution stings, they try to publicly shame them by putting their photos in the newspaper or on a website or something like that. And here, he was arrested in the course of their sting, but of course he was not arrested for anything related to prostitution, but the police were more than happy to create the impression that that's what he was arrested for.
And if you Google him today, 5 years later, you will still indeed see his mugshot in this article in the local paper. So Anya, tell us from there. Oh, and I wanted to mention that the significance of him going over 20 miles an hour was that in Illinois, it is illegal on a little rinky-dink motorized bike to go more than 20 miles an hour. So police said he went 24 miles an hour, whereas he says his bike was only capable of going 20 miles an hour. Anyhow, tell us more about his retaliatory arrest claim.
Well, I'm only happy that I'm not driving my motorized bike in Illinois, that I'm actually driving it in Texas and don't have to worry about that because I would be arrested, I'm pretty sure. I'm going way over 20 miles an hour. So anyway, the charges ended up, Lund is very upset, right? The charges end up being dismissed, but he files a 1983 action for retaliatory arrest. And he basically says, hey, I'm a journalist. I was exercising my First Amendment right, and they retaliated against me by arresting me. And the Seventh Circuit really makes a pretty quick work of that First Amendment retaliation claim. First of all, it basically says, remember this case, Nevis versus Bartlett, that came out in 2019, and Paul knows all about this case and can talk about it if you'd like to. So this case, Nevis versus Bartlett, basically says that the plaintiff pressing a retaliatory arrest claim must plead and prove the absence of probable cause for the arrest, right? And they're basically saying, look, there is plenty of probable cause here. He was going over 20 miles an hour in a motorized vehicle, which looks like a motorcycle more than a bicycle, and he was going the wrong way. So obviously they could have arrested him, and they did. Go ahead, Paul.
So Lund tries to fit himself into a very narrow exception that the Nieves case recognized. So the court in Nieves did say, as a general matter, if there's probable cause for arrest, you can't bring a retaliatory arrest claim. But there's a narrow exception, which is that if you are arrested for things that the police are letting other people get away with, and the police single you out. Like jaywalking. So the example the court uses is jaywalking. If everybody's jaywalking and the police only arrest the guy who's jaywalking and is also a critic of the police, then he is allowed to bring a First Amendment retaliation claim. So Lund tries to fit himself into this exception, and unfortunately for him... But the court disagreed. Yeah, the court holds him to a pretty high evidentiary standard if he wants to show that in fact other people are not being treated the same way he is.
So what kinds of evidence does the court ask for, Anya?
Well, the court in Nieves really is pretty explicit about its concern with police using their discretionary judgment, essentially, to arrest people based on wanting to retaliate against them, right? They use that example with jaywalking and basically saying, this is a crime of jaywalking, but police officers don't usually just arrest people for jaywalking. And we're really worried that this decision would be misread to apply to these kind of situations. And that's essentially how they create this very narrow, as they describe, exception. And you basically kind of have to, one way to establish that you fit within this discretion, within this exception, is to show that you must present objective evidence that you were arrested when otherwise similarly situated individual, not engaged in the same speech conduct, was not arrested. And the court here in the Seventh Circuit says that he is far from being able to present this kind of evidence.
Well, it sounds like he would have needed to show evidence that other people driving motorized bikes the wrong way down a one-way street were getting away with it. But where would that evidence even come from?
Well, and I think, the interesting thing here is that this demonstrates something that like anyone who's studied criminal procedure knows, which is that if you are on or in a motorized vehicle, the police will be able to arrest you if they want to, because they will always be able to find you for some traffic violation. Now here, the only reason the police followed this guy, and they testified to this, was because as he was leaving, he said, "Goodbye, officers." And apparently that cheesed them off, and they decided, okay, we were going to let this guy go, and now we're going to give him a hard time. So that was when they decided to arrest him, and they followed him. And, in this case, he took his motorized bicycle the wrong way down a one-way street. But even if he had not done that, they would have been able to stop him for some kind of traffic infraction, or just alleging that he committed a traffic infraction, and arrest him. So I think there are still real concerns that if you are a critic of the police can target you with very little accountability.
And the Seventh Circuit kind of seems to be very sympathetic to this idea that the officers were really, truly concerned that he was going to disrupt this prostitution sting operation. And they kind of wanted to make sure that he wouldn't do that. And that was a proper thing for them to essentially exercise this ability to arrest him for this kind of a violation, to prevent him from doing so.
Yeah, and I did not find that claim to be particularly credible. So I guess the idea is he's going to go back to his apartment and he's going to blog about the fact that there's a prostitution sting going. And then the Johns who were going there to hire prostitutes are going to see the blog post and avoid the sting. I just don't think that's credible. I think this is pretty clearly a situation where this guy is a well-known critic of the police, and the police saw an opportunity to stick it to him, and that's what they did.
So that's the case that essentially relies very heavily on a Supreme Court case, Nevis versus Bartlett. And Nevis relies on Lozman. And the Institute for Justice was involved in, and particularly Paul, you were involved in kind of our amicus efforts in both of those cases. Could you briefly talk about that?
Yeah, so one of the things that we are concerned about in these cases is the Institute for Justice, in addition to the litigation we do, we train activists, particularly in things related to property rights, and we teach them how to go and testify at public hearings. In the Lozman case that you mentioned, a guy was arrested at a public hearing basically because he was criticizing the members of the city council. And we were very concerned that, this could happen to exactly the kind of activists that we train. Now, Lozman has got a decent ruling, but then you have Nieves come along, and it seems to really narrow it. And, as I said, the police can usually come up with a justification to arrest you, particularly if you are anywhere near a motor vehicle. So I really don't think there are the kinds of protections that people need. And frankly, police do have way too much discretion for dealing with their critics.
Anya, there's also a municipal liability claim. In addition to suing the police, you sued Rockford. Can you tell us about that?
Yeah, that's interesting. The Seventh Circuit only deals with that in the footnote. And they're basically saying that one of the defendants was, in fact, the city of Rockford. They even refused to file a response, right? They're basically saying they did not properly, that this gentleman Lund, he didn't properly sue us, because he's essentially saying that we should be responsible under a respondeat superior theory of liability. And that's not how it works. And unfortunately, they're right in that argument, right? That generally, when you sue, let's say, a private party, like a grocery clerk at Whole Foods, and if they commit some sort of a, negligent act that results in injuring you, you can sue Whole Foods in addition to that clerk, and for respondeat superior theory. And it looks like this is what Lund tried to do here. He basically said, yes, these guys injured me, and you as a municipality should be responsible for this. But a municipal liability standard against cities is much stricter than a respondeat superior standard against, say, companies. In this case, he simply didn't really allege elements that need to be alleged in order to establish municipal liability, especially like a municipal policy or practice that specifically caused that injury. That it's not enough that a particular employee of the city caused the injury, but that a very explicit or implicit but very clear policy or practice directly caused that injury. So the municipal liability claim here probably would have not worked, even if it were alleged properly.
So does this count as an engaged opinion or otherwise, Anya?
I think, unfortunately, otherwise.
Okay, and with that, let's move on to the next case, which comes out of the Sixth Circuit. Paul?
Yeah, so this case, Lebomov Enterprises v. Whitmer, deals with the really interesting intersection between the Commerce Clause of the Constitution, in particular what's called the Dormant Commerce Clause, and the 21st Amendment, which repealed prohibition. So the Commerce Clause gives the federal government sole authority to regulate interstate commerce. And it has long been understood, in fact, since the very first Commerce Clause decision, a case called Gibbons versus Ogden, that the implication of this is that the states do not have the authority to regulate interstate commerce. One exception to that is the 21st Amendment, because the 21st Amendment gave states basically complete authority over the importation of alcohol into their borders. So Michigan, like many states, has a three-tier system of alcohol control where there's a separation between the manufacturers and the retailers, and that's the wholesalers. And Michigan amended its law so that retailers could directly send wine to consumers in Michigan. And retailers in Indiana, who are not part of Michigan's three-tier system, challenged that and said, hey, we want to be able to send directly to consumers in Michigan too. And the question is, what should control here? Does the Dormant Commerce Clause control, and so Michigan can't prevent the importation of this wine? Or does the 21st Amendment control, and they can prevent the importation of the wine?
This case is actually on the surface very similar to the two three-tier related cases that we did, both in the United States Supreme Court, and both are really big victories. Granholm, that dealt with essentially producers of wine and whether out-of-state producers can ship, whether it's a violation of a commerce clause for in-state producers to be allowed to ship directly to consumers, but for out-of-state producers to not be able to ship directly to consumers. And the second case, Tennessee Wine, which actually dealt with the residency requirements for folks who are retailers and coming into the market and wanting to sell alcohol. So on the surface, these two cases are very similar to the one at issue here, but I think that there's some seriously distinctive features, and we probably could talk about it. Paul, if you'd like.
Yeah, so what really distinguishes the Granholm case, and there was a companion case with that, which is the one we litigated on behalf of Juanita Swedenberg, who owned a winery right here in Virginia. So as you said, that case dealt with producers who were shipping directly to consumers, and the state was treating different producers who were similarly situated. It was treating them differently. So the in-state producers could ship directly and the out-of-state producers could not. Now, what distinguishes that case from this case is that here, the out-of-state retailers are not similarly situated to the in-state retailers. And that's because the in-state retailers are part of this three-tier system. And the idea of the three-tier system is to prevent the supposed evils of what are called tied houses. So those are bars or saloons that are essentially under the control of manufacturers and have this incentive to, I mean, I don't find the argument very convincing, but the argument is that if you have this level of control, there's going to be more alcoholism, more alcohol consumption, and the various problems associated with that. The Supreme Court has long said that states can have a three-tier system if they want, even though the middle tier is essentially just pure rent seeking, or in some cases just essentially a tax because the government runs the middle tier. If that's the case, then I think the panel makes a reasonable argument here that the state can keep out an out-of-state retailer that is not a participant in the in-state three-tier system. Unfortunately, that's bad for retailers, it's bad for manufacturers, and it's bad for consumers. And I think the supposed benefits of the system are extremely speculative.
Yeah, and the concurrence kind of hits on that, right?
Yeah, so Judge Sutton's majority opinion, basically just says, yeah, this is no problem at all. This is clearly constitutional. And then the concurrence, even though it concurs in the result of the case, it does sound a note of skepticism that, there's really, I think there's enough evidence here to uphold this law, but really just barely. And frankly, there's not a lot of evidence discussed in the case at all. What's really discussed is just sort of long-held assumptions about how three-tiered systems benefit the public, without a lot of empirical basis for that. On the one hand, it's kind of nice to see that concurrence making a nod towards judicial engagement and consideration of the evidence, but it's kind of the tiniest nod you can imagine, and certainly small comfort to the out-of-state retailers who lose this case.
And the interesting thing about retailers, too, in this case, is that unlike many of the states, and this is no longer the case, thanks to our victory in the Tennessee Wine and Spirits case, unlike many of the states, Michigan actually does not have residency requirements for retailers or even durational residency requirements for retailers. All they're asking is that you actually have an in-state presence. And kind of Judge Sutton kind of hits at that as well, basically saying that the laws that are on the books here are actually not as unreasonable as they look at the first glance.
Yeah, although I mean, part of that also is that if you set up an in-state presence, the retailer can only buy their alcohol from the in-state wholesaler, and so they
Right.
are limited to selling the products that the wholesaler provides. And that's one of the
Right.
things that the plaintiffs in this case argue is that, look, we have customers who want to buy these wines or spirits or whatever that the wholesalers in Michigan just don't provide because maybe there's a small market for it or whatever. And so the result is that consumers pay higher prices for fewer choices. And Judge Sutton basically just says, yeah, that's the cost of doing business. That's the way the 21st Amendment works. And at least under existing precedent, he's more or less right.
Okay, and with that, let's move on to the final case, which comes out of the Fourth Circuit. Paul?
Yeah, so this case is American Association of Political Consultants versus Barr, although now it can appropriately be styled Barr versus American Association of Political Consultants because the U.S. Supreme Court has granted review in the case and is going to be hearing argument. It was originally scheduled for this month. I'm pretty sure it has been rescheduled for a telephonic hearing next month. We did an amicus brief in the case, and the case involves the Telephone Consumer Protection Act, which for the most part prohibits so-called robocalls, so automated phone calls with a pre-recorded message. And under the TCPA, as it was originally written, there were very few exceptions. The only ones were an emergency exception, and then, well, now I can't remember what the second one was. There was another it was if you had prior permission from the person to make robocalls to them.
A consent.
Yeah, if you had their consent. So a few years ago, in 2015, Congress amended the law and added a new exception so that people who were attempting to collect debt that was guaranteed by the federal government were no longer subject to the TCPA. When this passed, the American Association of Political Consultants sued, and they said, look, you're drawing content-based distinctions on who is allowed to make these calls. We want to be able to do it to do get out the vote drives or whatever it is that political consultants do. And, we should be allowed to do that if collectors of government debt are allowed to do that.
And so, Anya, what does the Fourth Circuit wind up saying?
Well, it's very interesting, right? But the Fourth Circuit, and as Paul mentioned, that it's actually going up on the third. The Fourth Circuit agrees that that particular exception is actually unconstitutional. That it's content based and it doesn't meet the strict scrutiny test. But it also says that particular restriction is severable, and as a result, the entire law, save the exception, should still remain in place. And that severability question has been really interesting and has been before, it's also probably going to be before the court in the Affordable Care Act case, right, Paul?
I'm sorry, I'm not sure which Affordable Care Act case you're talking about.
So it essentially the ACA Affordable Care Act mandate that
I know the one. I know. So this is the one where they repealed the tax, or they set the tax to zero. And so the question is, if it doesn't raise any revenue, is it a tax? And if it's not a tax, that means it's unconstitutional. And if it's unconstitutional, is the individual mandate severable from the rest of the ACA, or does the whole case? Okay, I remember the one you're talking about.
Yeah, and so the severability issue seems to be kind of really driving force here. There doesn't seem to be much controversy about whether that particular exception is constitutional or not. What's really important is whether, if you get rid of this, it makes the entire law fall.
Yeah, so, I really think severability in this case is actually kind of a red herring. And I think it reveals that the panel was thinking about this case in the wrong way, because the practical effect of the ruling is that the plaintiffs won, but they get no remedy. And in fact, not only do they get no remedy, but people who had the right to make robocalls, who were not before the court, who did not have the opportunity to weigh in on this dispute, had their rights extinguished. So that seems like it raises certain due process problems. And throughout the opinion, the court keeps talking about this unconstitutional exception, and we can save the law by striking the unconstitutional exception. But I think that misunderstands it because it's not the exception that is unconstitutional. There's nothing unconstitutional about saying that collectors of government-backed debt can make robocalls. What's unconstitutional is saying that political consultants may not make robocalls unless that law satisfies the relevant level of First Amendment scrutiny. And here, the court says, well, it's unconstitutional because it's under-inclusive. It leaves out these government-backed debt collectors. Well, what's really going on here is that the exception is not unconstitutional. The exception is evidence that the law doesn't really further the purpose that it's supposed to be furthering. And that makes the substantive core of the law unconstitutional. And the court really had to remedy that constitutional violation. And the remedy that they choose doesn't do that at all. Instead, what the court really does is it says, well, this law is unconstitutional, so we're going to rewrite it in such a way that it would be constitutional. And that, I think, actually exceeds the judicial power, and it's inconsistent with what courts in declaratory judgment actions are supposed to do, which is declare the rights of the parties. And in this case, the court should have declared that the government can't prosecute political consultants for making robocalls because the law is unconstitutional as applied to them.
As you say, Paul, the practical effect is that third parties, namely the people who collect government debt, who were never in court, lose their rights under the Fourth Circuit's ruling. It seems like that might have a larger effect on civil rights litigation generally if that sort of ruling becomes commonplace. Do I have that right?
Yeah, I think that's exactly right. And I mean, in basically any other circumstance, these collectors of government-backed debt would be considered, what used to be called indispensable parties to the litigation. They're people who have to be joined to the litigation because their rights are being adjudicated. And here the court just sort of skates past that. It leaves us with this sort of really weird result where the plaintiffs win, they get no remedy, people who weren't in the court lose their rights, and basically nobody's happy. The government in this case petitioned for certiorari, and also the political consultants petitioned for certiorari, and the court granted both petitions.
Well, I will say there probably are some people who are happy. That is, people who don't like getting robocalls. I mean, this is not a sympathetic group of plaintiffs. Does that have any bearing?
That's a fair point, but I think the counterpoint to that is how many people have ever picked up a robocall and said, "Oh, thank God, it's just a debt collector. It's not someone trying to get me to go out and vote." All right, that's never happened, and yet that was the way the law was structured. So if the government thinks, you know what, it's actually fine if debt collectors make robocalls, I think that means that it's fine from the government's perspective if most people make robocalls. And this is why it's important that the government regulate in an even-handed way, that it not have under-inclusive laws, because it allows the government to play favorites for some speakers and not for other speakers. And here, it's obvious why the government wants collectors of government-backed debt to be able to make robocalls. And it's not, because there's something particularly special about their calls or that they don't raise the problems that other robocalls raise. It's just because the government wants the money.
If you were to read the tea leaves, why do you think the cert was granted? And what do you think is going to be the kind of like the main interesting thing for the U.S. Supreme Court to take up here?
It's really difficult to say because, in the last few years, the court has issued some rulings which are extremely speech protective, and it's gotten strong pushback from lower courts, particularly on this question of whether laws are content-based or content neutral. I think the court is going to stick to its guns and say that this law is content-based. But the court has also issued one bad ruling on under-inclusiveness, and this was a case called Williams U. Lee versus Florida Bar, where Chief Justice Roberts, writing for the court, really took a lot of the teeth out of under-inclusiveness as it applies to the narrow tailoring analysis. And then severability is, I think, anyone's guess. I have no idea what the court's really going to do with that. So, I don't think this is going to upset the current consensus on the court about content neutrality, but it might make some of the implications of its stronger pro-First Amendment rulings not as great as they originally appeared.
Okay, and with that concludes the show. Thanks for listening, and be sure to tune in next time for more Short Circuit.